And we're live. Hello, everyone. Welcome to Legal Lunch and Learn, a weekly live show where we ask an expert your questions on a legal topic. My name is Cindy. I am the staff attorney here at Maryland Legal Aid. My co host today is the director of our Community Lawyer Initiative, attorney Megan McDermott.
Hello.
And our guest star for today, and of course, our expert on Wilson State, attorney Charlotte Ahern.
Hello.
And of course, working tirelessly in the background is our production engineer, Alec Chase. And so today's topic is wills, advanced medical directive, and powers of attorney. So this is going to be a two-part show. Today we're going to talk about the documents that you might need towards the end of life or for those things that might just happen unexpectedly. Next week we will have Charlotte back, and we will be talking about things that you might need to know when a loved one pass away. So for today, if you do have questions about wills, advanced medical directives, or powers of attorney, please make sure to leave them in the comments down below. And of course, you can also direct message us or private message us if you would like to remain anonymous. Before we get started, I do have some disclaimer. Just because you're taking legal advice from our show, it does not establish an attorney-client relationship between you or any of the attorneys here today, nor does it establish attorney-client relationship between you and Maryland Legal Aid. If you do have an immediate legal issue that you do need help with, and of course, if you're a Maryland resident who qualifies for our free service, please contact us and we'll have that information down in the comment. Our email here is lawyers@mdlab.org. That is LAWYER@mdlab.org. Our phone number here is 443-451-2805. For those who do need subtitles, our show will be uploaded to YouTube after the live event ends. So make sure to check us out on YouTube if you do need captions. So with that out of the way, that's a long intro. With that out of the way, let's talk to Charlotte. Hi, Charlotte. How are you?
I'm great. How are you?
So just to get us started, tell us a little bit about yourself.
Sure. My name is Charlotte Ahern. I work for Maryland Legal Aid in the Community Lawyering Initiative. I work with Cindy. I am born and raised in Baltimore City. I went to college here. I went to law school here, and I don't think Baltimore will ever be able to get rid of me.
That's good to hear. And I'm so happy to hear that you're like all the other people in community lawyering are in the community here in Baltimore City. So with that, thank you for that. So let's dive into today's topic. Well, I'm going to divide today's I want to say lecture, but today's show into three different sections. So let's start with wills. To start, what exactly is a will?
So, a will is a legal document that explains what an individual wants to have happen with their assets and their belongings after they pass away. And it can also include what steps they want to have taken for their children after they pass away.
So what happens if a person die without a will? And we know that people, pass away without a will all the time.
Yes, all the time. Unfortunately, I always advise individuals if all they have is clothes on their back, they should definitely still have a will. It really just helps your family out mostly when you pass away. So we advise that everyone should get a will, even if they think that they don't have any assets. But when an individual dies without actually having a will, the property or assets or belongings pass through what's called intestate, which basically all of the assets and property will then go to the different heirs of that individual. Say if that individual had two children, all of the assets would then pass to those children, opposed to if someone was specifically named in the will that those assets were supposed to pass to.
All right. So in terms of what goes into the will, you said, we have a will, you talk about your assets and maybe guardianship of minor children. Anything else that might go in there?
Yes, I mean, all of your assets, you can make what's called bequests, which are, you can separate them into specific bequests or general bequests. A general bequest would say something along the lines of, I would like all of my property to go to this person. A specific bequest would say, I want my earrings, this specific pair of earrings to go to this specific person. You can also provide for funeral arrangements in your will if you haven't already figured that out.
Wait, for funeral arrangement, do you mean can a person say, I would like to be cremated or I would be like to be buried at a certain spot?
Yes, most of those things are taken care of prior to a will being written, in terms of financially as well, because certain plots cost money and things of that nature. But you can specify in your will how you would like that to take place, how you would like your funeral to take place. You should also in your will make sure that you list a personal representative, which a lot of the times people say the word executor, but it's the actual term in Maryland is personal representative.
That sounds like a lot of things that you need to put together and get ready before you get a will written or done. So what kind of people should make a will? Is it for anybody or are there any requirements?
Yes. So you have to be an adult, so 18 years of age, and you have to be of sound mind. This of sound mind or competent, it typically is a person has to understand what a will is. They have to understand the relationship between themselves and the beneficiaries. They have to understand what kind of property they own. That typically classifies as somebody who is of sound mind. Like I said, I think everyone should have a will if you're an adult, but obviously it definitely makes more sense if you are, a little bit older.
Yep. And of course, you don't have to be, in your golden years and anticipating your immediate demise to go look for a will. So, absolutely, any adult should look into getting that done. So, speaking of that, is there a way, what is Maryland's way to make a will official, if you will?
So to make it an official legal document, you have to sign the will in front of two witnesses, and those two witnesses have to sign it as well, attesting to the fact that they watched you sign it. It doesn't have to be notarized. However, it's definitely a good idea to get it notarized if you want to. It's not a requirement. And the witnesses can be anyone. It could be a beneficiary of a certain bequest. It could be the personal representative. It could be two people you've never met that you find on the street. It doesn't matter who the individuals are. They just actually have to watch you sign the document, and then you have to sign the document as well. You can't be in another room and say, hey mom, I just signed this document. Can you come and sign it? They have to physically witness you sign it.
Can your personal representative or executor of your will be one of the witnesses?
Yes.
All right. What if it's a beneficiary or someone who's might be gaining something from the will?
It does not matter. It doesn't. They can be a witness as well.
All right. So after you get that official document done, or as we call it, executing the will. So after that happens, what should you do with that document?
You want to obviously find a safe place to keep it. We don't recommend that you make too many copies of it, but you definitely should, I think, at least make one copy for yourself or for your personal representative. If you do make copies, it shouldn't be any more than two. And then what I typically advise is actually to take the original and bring it to the register of wills in your county. And then for a small nominal fee, they will hold the will for you. They'll register the will for you and keep it in their, vault that they've had for 1,000 years. And then that way, when you actually pass away, your personal representative, there's no mad scramble for where's the original will. Your personal representative can then just go to the register of wills in your county and ask them to start the process.
Right.
But I wouldn't make more than two copies, and keep one of the copies in a safe place, and let your PR know where it is.
All right. So once you get all that done, what if you change your mind later on?
There are two different ways you can completely revoke that will and write a new will, and that needs to be specifically stated in the new will that you're revoking the previous will. Or you can write what's called a codicil, which is kind of like an amendment to the will. It's just like an addition. But those are the two options that you have if you want to change something in the will.
And of course, we here at Maryland Legal Aid will also recommend that you talk to an attorney,
Yes.
and we are free attorneys in Maryland for qualified residents.
Yeah.
Talk to an attorney when you want to change something in your will, because I think sometimes it can get kind of complicated.
Yes, that is very, very true. Definitely talk to an attorney. If you qualify for our services, we write wills for free. We will help you if you qualify for our services. Definitely talk to us if you want to change your will or write a will in general.
Yep, or write a wedding journal. So what are tell us about some common reasons why someone might change their will. So if they got their will done and maybe something happens in their life that should maybe be a trigger for them to go, oh, okay, I need to change my will when this is done.
Yeah, definitely. I think like what you just said, if something happens in their life, a major life event, if you get married, if you have a child, if maybe one of the beneficiary dies, you've named somebody in your will to receive a particular asset, and then that individual passes away before you, you might want to change your will. I'm trying to think of what else. If you adopt a child, or if say something just happens with a particular person that you're no longer in contact with and you don't want them in your will, you might consider changing it.
Yep, absolutely. So for those who are interested in what happens after a person dies, whether they have a will or not, please stay tuned for next week. We will come back and talk about that. So with that said, let's go to our other document that we are going to talk about today, Advanced Medical Directive, and very confusingly is also known as a living will. But let's stay with Advanced Medical Directive so it's not confusing for our listeners.
Okay.
So first of all, what is it?
It's another legal document that essentially it describes what type of healthcare decisions you want to make in the event that you become incapacitated, or something drastic happens and that you can't make decisions for yourself medically. The Advanced Medical Directive lays out what you would like to have happen for your end of life, essentially.
Can you give some examples of what those kind of decisions might be?
Sure. So if you want to have life-sustaining support, you want doctors to try everything possible to try to keep you alive. If you want to have doctors not necessarily be on life support, but give you nutrients so that your body is still physically alive and just kind of eases into the afterlife. I'm trying to think of anything else. Certain, medications like pain medications and things like that. If you don't want any type of nutrients or life-sustaining support, if you just want to be given pain meds and kind of go that way, those are some of the options.
Right, very serious topic
Yeah.
today, I'm
Yes.
afraid. So those sound a lot like, very personal and medical decisions. So should a doctor be involved in these kind of cases?
100% we advise that you talk to your primary care physician or to anyone that you feel comfortable with that has is a doctor about these issues, because it's something that you want to make sure that you understand, because even legally a lot of these terms aren't really legal terms, they're medical terms that even the best lawyer in the world might not fully really understand what the medical consequences of them could be. So we definitely advise that you talk to a primary care physician about what the different options are.
Now, what if I wanted so that if I become incapacitated, I'll have someone to make those decisions for me.
Mhm.
Can I do that? And what is that?
Yep, that is called a healthcare agent. So this is someone that makes basically like what you just said, all those decisions for you is your healthcare agent. Um, you want this to be similar to a personal representative. You want this to be someone that you trust, that is close to you, that, is younger. That's not to say that, people pass away all the time, no matter the age. But you definitely want it to be someone that you trust and have full confidence in, that will make decisions based on what's best for you.
Um, so in terms, we do talk a lot about, end of life care and things like that in terms of advanced medical directives.
Mhm.
Um, who who do you think, would you recommend to have something like this on their file?
So similar to the will, I mean, it's always good to have one, someone that's an adult, that's competent. But I think even more so right now, just everything that's going on with COVID-19 and the unfortunate healthcare situation that we have right now. I think it's smart for everyone to have one. But particularly if you have maybe a pre-existing condition, or if you are already in some type of end of life care, facility, you should definitely look into it, because you don't want to burden your family with these decisions, when you could just state clearly what you want to have happen.
Right. Or even have, I think most commonly, and we see it in the news all the time, are family members fighting over who gets to make the decision as well, I think.
Exactly. And
Yeah.
I'm one of four, so I know with my parents, I said make those decisions, because we will fight about what actually ends up happening, and it tears families apart.
Yep, absolutely. So if someone wants to have one done, how do they go about getting one? Either in terms of, is there a form that they can fill out, or do they need to talk to a lawyer about it?
Sure. I mean, they should definitely, with everything, you should always consult a lawyer. But also with this, you should consult a medical professional. I do know that the Attorney General's website does have a form and has instructions, that we typically refer people to, which is, it's very informative. But at least for making sure that it's a valid document, you do need two witnesses to it as well. So that's something to keep in mind. Um, I believe you can have a notary be one of the witnesses also, but I don't think that a notary is required.
Yep. Just so it's slightly different from a will. What if you're not able to physically sign a document? Can you get this done orally somehow?
By physically sign a document, are you competent? I guess.
Yes. Yeah,
Oh,
I mean, like, for someone who's too weak to maybe set up, but still conscious and
okay. Then I think that, I guess, really depends on the circumstances, because there would have to be a determination made as to whether the person was actually competent or not. So if that's the situation, I would tell that person to contact legal aid, because maybe a lawyer could then speak with the person over the phone to actually get some more information as to their competency.
yeah, absolutely. So if someone already has one done, they decided what they want and they fill out the form from the Attorney General's office, which I have looked at before. It's a very long form,
Yes. Yeah.
and it's very detailed. And that's good. I think a lot of times we don't think about the things that we need to really have a hard conversation about. But anyway, if you did fill out the form, you got everything ready, and you got it executed, as we call it, making it official. What do you do with that document?
So similar to the will, obviously you want to keep it in a very safe place, but you want to share it, also with your primary care, or say you're at an elder care facility, you want to share it with nurses there. There's also, with the Attorney General, I believe that they have now like an online system where they can electronically have the document, so that you can then send it electronically to whatever type of doctor you want to send it to. But I think that you obviously need a copy, and your healthcare agent, if you should also have a copy.
What if you change your mind later? Can it be changed?
Yep. That is easier to change than a will. You can, if you change your mind later, it's whichever document is the most recent for your advanced medical directive. That's going to be the document that is taken for what needs to be done.
Absolutely. Sounds like this is a more complicated one where you need to talk to two different kind of
Yeah,
professionals,
yeah,
and have, real hard conversation before you get it done.
yeah.
So I do see that we have some questions coming in. Just for those who are, asking questions, we will address them towards the end of the show. So with that said, let's move on to power of attorney. So first of all, what is it?
It's a legal document.
Yay!
So it's a legal document that essentially gives another person the authority to act on your behalf in certain manners. So there's two different individuals in the power of attorney. It's the principal and the agent or the attorney in fact. So the principal is the individual giving somebody power, and then the agent is the person that receives the power.
I think you also said attorney in fact.
An attorney in fact. It's either one. It's either agent or attorney in fact. You can
Yep.
say either.
Yep. So what kind of decision, or what kind of power, let's say, can you hand to your agent?
Well, there's two different types really. There's a general power of attorney, and then there's a limited power of attorney. So a general power of attorney is basically in all kind of business personal matters. That includes things like bank accounts, taking out loans, real estate, suing people. That goes into the general power of attorney. The limited power of attorney is just for limited transactions or limited things. Um, what else would go into it? I mean, it's really mostly financial, but you can make a limited power of attorney as limited as you want it to be for one specific financial transaction. And general is just everything.
So why so it sounds like, someone's going to be touching my money, or using my social security number.
Yeah.
While I'm still, conscious and competent, why would I want something like that?
So a power of attorney doesn't limit the principal. Say I'm the principal and you're the agent. It doesn't limit me as the principal from doing whatever I want to do. It just gives you authority, depending on what it says, to do certain financial transactions for me. So a lot of times, obviously you have to be 18 and you have to be competent to have a power of attorney. But you see this in real estate transactions. You see this also for individuals that are in the military that are, say, they're deployed and they need someone to take care of their bills or to take care of various matters, in the United States or wherever they may be. So you see powers of attorney in that particular situation. Also with, I'm pretty sure I mentioned this, but real estate transactions, if you need assistance with that, powers of attorney help with that.
Yeah. So talk about requirements for someone to give someone else that power. Do they, is there an age limit? Do they have to be competent or any other restrictions?
So they have to be an adult, and they have to be competent, obviously. But at least in terms of executing or making it an actual legal document, it has to be in writing. It has to be signed by both. But we'll keep going with this pretend situation where I'm the principal and you're the agent or the attorney in fact. Has to be signed by me, the principal, and acknowledged by the principal in front of a notary. And it has to be signed by two witnesses, one of which can be the notary. That gets a little hairy there, but it's a little bit more than a will in terms of the requirements. But those are the basic requirements.
Yep. Can one of the witnesses be the agent?
Can one of the witnesses be the agent? I don't think so. That could have changed though. Sorry, I don't have the answer to that. I'm not as much of an expert on powers of attorney as I am on wills. But I don't think so. I would say, just to be safe, I wouldn't do that, because you don't want it to look like there's any type of the agent kind of forcing the person to do that, which you know, sometimes people can be in situations where they're not fully competent and someone's kind of forcing them to do that. So I would not do that personally myself, but I would have to double check on that.
Yep, and of course, come talk to us for a free lawyer. I don't know how many times we're gonna
Yeah,
say
I
it
know.
this in this show, but we do take cases for free. So I'm about to get into a little bit of legalese here.
Oh gosh.
So we have this thing called durable power of
Yeah.
attorney in Maryland. Can you explain what that might be?
So a durable power of attorney essentially means that even after the individual loses competency or it becomes incapacitated, it's still the power of attorney is still in effect. So states vary on this issue. Um, it's presumed to be durable unless the document says otherwise. So if you only want to give someone the power for a certain period of time, make sure you put that in the document, because then that's when that power will cease, unless the individual a power of attorney is durable unless otherwise specified, unless the individual dies. The power of attorney is a living document. So once you pass away, that document has no authority whatsoever.
Right. So that will be one way to end the power of attorney. Are there ways to change it? You know, if you change your mind later, before you die, obviously.
If you want to rescind it, if you want to, it's up to you, depending on what the actual, the most annoying lawyer answer ever. It depends on what the document, says. But if you want to rescind it, or if you don't feel comfortable, if you want to revoke anything, you certainly can do so.
Yeah. So that's all the questions that I got before the start of the show. So now I'm going to turn this to our co-host Megan for some of the questions that we received during the live.
Thanks, Cindy. Hi, Charlotte.
Hi, how are you?
I'm good. Thanks for all that information. We do have a couple of questions. So this person said, my mother is deceased. She left her sister some property, I don't know what kind, some property in her will, but the sister actually died 2 years before mom.
Okay.
And mom never changed the will. So this person wants to know what happens to that property in this situation.
And there wasn't a backup person listed in the will?
I don't think so.
Okay, so this is another thing, is that we typically advise that you have kind of like a backup. So if this person dies before me, I then want to give my property to this person instead, just because these situations do happen. Typically in Maryland, we have what's called like an anti-lapse statute, which means that if that sister, I think if that sister had a will and described how she wanted her property to be divided, it would then go by the will. Or if the sister died intestate, then it would go to her heirs.
Okay, thanks. Mm-hmm. So a question we get a lot when we were out in clinics before COVID, the clients would ask me, why do I need a will if I don't own a house and I don't have a lot of money? Are there reasons someone might want a will even if they don't have a lot of things?
Sure. You never know what you can acquire prior to your death. So even if you currently don't have any type of assets, you might come across some assets later on. Also, in the situation that you just described, if you have a child, say, and you passed away, you would want to make sure your child gets whatever assets that could possibly be available to them. And if, say, your parent or your grandparent, does not predecease you, they might pass some assets to you, and then you would by then pass it to your children. I think that there's no harm in it, and it just makes life a whole lot easier for your family. And you definitely don't want to cause any issues for fighting over nominal assets. So there's really no harm in having a will. And Maryland Legal Aid writes wills for free for individuals that qualify for our services. So it wouldn't cost you any money for us to write you a simple will if you qualify.
Okay, so it sounds like you could have a really simple will that maybe only had a few lines in it almost, right?
Yep.
The saying,
Yep.
You might not have anything right now, but if I have any assets upon the time of my death, they would go
Yep.
to my
Yep.
daughter or whoever.
Exactly. Yep.
Great. And then if you have minor children,
Mhm.
can you designate a care person or a guardian for them in your will?
Yes. Yes. And you should. And you should. And also you can designate a guardian of a property that you want to go to your minor children, so that say you own a property and you have a child, but the child is 13 years old and you pass away, that child can't take that property yet because they're not an adult. So you can have the same person be the guardian of the child and be the guardian of the property to make sure that it stays, as an asset within the family, so that once the child becomes an adult, the property that can then pass to the child.
Okay. So what about people who, we're Maryland Legal Aid, so we practice in the state of Maryland. But what about people who maybe have moved here from another state and they made a will in Pennsylvania? Do they need to do a new will in Maryland? How does that work?
So long as the will was executed in Pennsylvania in accordance with what Pennsylvania law requires, it should be fine. Or if it was executed with what Maryland law requires, it should be fine. But so long as it is presumed, so long as it is valid in the state in which it was executed, then Maryland will say that it is valid as well.
Okay. Would it be easier for your family to do a new will in Maryland, or does it not matter?
Because we write wills for free, then yes, of course, we could write a simple will. But if it was a very complex will where maybe a trust was set up or something like that, I would definitely advise to consult a trust and estates attorney to just make sure that you're doing everything, that you should be doing.
Okay. And then things like life insurance. So this person wrote, I heard that I don't need to designate my life insurance proceeds to a specific person in my will. Is that true?
So there's a difference between probate and non-probate assets. Probate assets go through the process of probate, which is the Register of Wills. Non-probate assets do not go through probate. That includes things that already have beneficiaries designated, life insurance, a pension. If you have a deed that is, a joint ownership with the right of survivorship, those are non-probate assets. So that would not, even if you put something in your will stating that you wanted your life insurance to go to somebody else, that clause would just not be executed or followed. It would go through who the beneficiary was in the life insurance policy.
Okay, so that's only for specific types.
That's always for
property, essentially.
Yes, that's only for very specific assets.
Okay, so things like your bank account would not fall under that.
If your bank account, it depends on how your bank account is set up. Most bank accounts don't have beneficiaries listed. Some of them do, but typically no. Your bank account is not. It is considered a probate asset. That can get a little complicated, but typically it's not a probate asset.
Okay. I think you kind of already answered this question, but let's just go over it again because somebody asked on Facebook. So for younger-ish people who write a will and then they accumulate a significant amount of wealth or assets later in life, so say that they earn 10 million bucks after they write the will, what ends up happening? Yes, lucky them. What ends up happening? Is it better just to edit the will? Or they said it's probably better to edit the will, but is there any way to write a dynamic, they called it, will, like specify who newly acquired wealth should go to? I think you kind of already said you could make a
So
generic clause.
so editing is no, it's not called editing. It's you would write a codicil, which is an amendment, or you would write a completely new will that would revoke the previous will. If you, congratulations, just came into $10 million, absolutely go to a trust and estates attorney, revoke your previous will, and write a completely new will, set up a trust. You can set up so many things. I would highly advise that individual to go to a trust and estates attorney to figure out how they want their will to be written.
Okay, so I think maybe for most of us, we're not going to come into $10 million, but most of us, a lot of us do accumulate more wealth as we get older, just through working and investments and different things like that. So it sounds like it might be good practice to revisit your will potentially every couple of years and decide if you should rewrite it. Does that sound
definitely
correct?
Yeah, definitely. Relationships change. People have children, people die. This is, we're talking about some morbid things today, but it's really particularly now, like I said earlier, with COVID-19, you definitely want to make sure you have all of these documents ready to go, because it's really just about your family afterwards. You just want to make everything easier for your family. It's already going to be difficult enough dealing with the death of a loved one, so you want to make sure that this is a smooth transition for people.
Okay. So talking a little bit more about PRs, personal representatives, this person has a really dramatic family and they want to leave the family thing. So they don't want to name any of them as their PR. So what do you do if you don't have someone you want to name as your PR? Is there an alternate type of person you can use, or how does that work?
Yeah, so you don't have to have it be a family member, just FYI. It can be someone that you just know and trust, that would execute your will in accordance with the terms. You always want to have a backup in case the first person or whomever can't execute it, or for whatever reason, maybe they predeceased you. That question about whether who can be appointed as PR can be a little bit complicated. Individuals that have a lot of assets typically have an attorney as their PR. The court can also appoint a PR sometimes. I could also go and appoint myself PR of somebody's estate. I don't know why I would, but just appoint myself as PR of somebody's estate. And then it would be up to someone else to come forward and show good cause as to why that person should be the personal representative. A lot of times we see if there's no surviving heirs or beneficiaries and there's a foreclosure going on, the firm for the foreclosure company will open up the estate and they will appoint themselves as the PR of the estate so that they can move forward with the foreclosure. But the answer to that question can get a little complicated. So I know I just kind of went all over the place. But if you have a specific situation about a personal representative that you might need assistance with, you should call us, and we can try to look at those facts more specifically.
Okay. So it sounds like a backup person is crucial, whether it's your will, and can you have a backup person in your advancce directive and your POA as well, or does it have to be a specific person for those?
POA, I guess you could. I've never seen that because that's not really how that document works. I've never seen that before. That's not to say that it couldn't happen. I've just never seen that. For your advanced medical directive, I'm pretty sure you can have it. Well, but that's also that's for the healthcare agent. So for your healthcare agent, you should be able to assign a backup.
Okay. And then what about people, say somebody comes and asks me to be their POA. Can I say no?
You can, rescind your whatever powers. You don't have to, but that is a little rare because typically that's a conversation that you're already having with somebody, that people aren't just randomly assigning people as their powers of attorney, because they can open bank accounts, they can do financial transactions. So that's very rare, unless it's that you can't execute the duties and you are coming to the end of your life. So you said, you know what, I got to rescind this. I can't help you anymore.
Okay. And so if someone did name me a POA, there'd be a document, the document would clearly state sort of what my responsibilities are, correct?
Yep. And you have to act in the best interest of the principal. So, whether that's opening up a bank account or selling a property, the standard is that you're acting in the best interest of the principal.
Okay. And one final question about if say I'm the POA and the person passes away, what happens then? Do I still have any responsibilities or any rights to their property?
No, but it's only until if you're acting in the best interest of the principal and you don't know that the person's deceased yet, when you find out the person is deceased is when everything kind of stops. So like I said previously, the powers of attorney, that is a living document. So when the person passes away, they cease to have any legal authority. However, there can be a lag time sometimes for when an agent finds out that the person passed away. So you could have taken this transaction or two during that time that you find out, versus when they actually died. So long as you were acting in their best interest, those transactions are valid. But that, okay, again, that's a very rare circumstance, because most times, people that are in this position are communicative, and unless it's like some type of business relationship.
Okay.
Yeah.
Okay, well, thanks. Those are all the questions that I see. So if anybody has any before we wrap up, feel free to send them along. And for now, we'll bring back Cindy.
All righty. So before we wrap up, Charlotte and I like doing this part because it's my favorite part, and I think sometimes the most useful. For our fellow viewers out there, what would you say is the most important thing that you would like them to know about the documents that we talked about today?
Get them done. Get your will done. We write wills for free for people who qualify. If all you have is clothes on your back, you should have a will. They're very simple to execute. It's not a hassle. We write them for free if you qualify. So I definitely would suggest that they get the ball rolling with that, particularly just because of the state of the world right now. With the advanced medical directive, I would say consult with the primary care or with the doctor. And then with the powers of attorney or power of attorney, if they have questions about that or are thinking about that, they should call us or call an attorney, because that, that document can lead to certain issues.
Yep. Thank you so much. So next week, I will still be talking with you, Charlotte. And we're so happy to have you for two consecutive episodes. Maybe we can call this the season finale. It's a two-parter.
Oh, yes.
Season one. Season one is an end. But next week, we'll have you back on again, and we will be talking about, what happens when a family member dies, either intestate, which means without a will, or, there is a will and you don't know where it is, and all of the mess that comes with it. So for our viewers out there, if you do have a question about what happens or what to do when a family member dies, please leave a comment down below, or you can email us or private message us if you want to remain anonymous. And of course, remember, if you find these videos informative or helpful, please share them. And of course, tune in next week. We'll be live again Tuesday at noon right here. Thank you so much and have a good weekend.